Federal court in California holds that Donald Trump violated the Posse Comitatus Act. Welcome to Law and Society. Please subscribe. Today I'm going to go through the ruling and read you the introduction and excerpts from the ruling that both explains what the Posse Comitatus Act is and also the limits to it. And there's a little procedural quirk here where this is just one part of a larger case that California has brought. And so there is an appeal pending on a preliminary injunction already, while the trial court moved under rules of civil procedure to a trial on the merits on one of the claims brought by the plaintiffs, which is violation of the Posse Comitatus Act. And the appellate court in the Ninth Circuit ruled on the basis of a different act that Donald Trump used as what Donald Trump's regime called was an exception to the Posse Comitatus Act. But this court holds that it is not so. And by demonstrating and by holding a hearing on the conduct of Task Force 51, which was deployed to Central District of California, this ruling says that those actions were in violation of the Posse Comitatus Act and that the regime did not have the power to change the laws, the training that involved training the personnel on how far they could go under the Posse Comitatus Act, because they were trained on the Posse Comitatus Act, but given instruction not to follow part of their training, which the court brings up and says that those are the violations of the Posse Comitatus Act, and the government doesn't have the power to say, no, those are exceptions based on a separate statute, which is a statute, if it was used, would undo the whole purpose of the Posse Comitatus Act and even the Insurrection Act. So with that was sort of a brief of what the ruling was. Now I'm going to read you excerpts. So the court starts with, Congress spoke clearly in 1878 when it passed the Posse Comitatus Act, prohibiting the use of U.S. military to execute domestic law. 140 years later, Donald Trump deployed the National Guard and Marines to Los Angeles, ostensibly to quell a rebellion and ensure that federal immigration law was enforced. There was indeed protest in Los Angeles, yet there was no rebellion, nor was civil law enforcement unable to respond to the protests and enforce the law. Nevertheless, defendants' orders and contrary to Congress's explicit instruction, federal troops executed the laws. The evidence at trial established that defendants systematically used armed soldiers and military vehicles to set up protective perimeters and traffic blockades, engage in crowd control, and otherwise demonstrate a military presence in and around Los Angeles. In short, defendants violated the Posse Comitatus Act. Moreover, President Trump and Secretary Hegseth have stated their intention to call National Guard troops into federal service in other cities across the country, thus creating a national police force with the president as its chief. And then I told you about the procedural thing happening, and this court is just going with the notion and the claim that the government violated the Posse Comitatus Act based on the training of Task 51 troops. They received training on permitted scope of their activities under the Posse Comitatus Act. The training materials for Task Force 51 provided that active duty military personnel may not provide direct active assistance to civilian law enforcement authorities by performing law enforcement functions unless a constitutional or an act of Congress exception specifically permits it. Major General Scott Sherman, who was in charge of teaching the task force, ensured that the task force knew that they weren't allowed to do any law enforcement actions. And there was a slide in which it said that the PCA, the Posse Comitatus Act, prohibits active direct pursuit, arrests, apprehension, seizures, evidence collection, interrogation, informant, security patrols, traffic control, crowd control, riot control. Additionally, the PCA prohibits any other activity where civilians are subjected to military authority that is regulatory, prescriptive, or compulsory. But then after that slide, they were orally instructed that the four functions of security patrols, traffic control, crowd control, and riot control were subject to a so-called constitutional exception to the Posse Comitatus Act. So they were going with some other law saying that those four instances that the military could, under the exception, be used as security patrols, traffic control, crowd control, riot control, when they really could not under the Posse Comitatus Act. So then the court goes on to explain the operations in Los Angeles County, operations, the Task Force 51's operations, talks about the operations of Los Angeles County and the future of the National Guard in California, and the fact that there's still 300 Posse Comitatus Act violators, National Guard people with bad instructions on how to follow the Posse Comitatus Act, who are still stationed in Los Angeles. The court went through the founding era and the Reconstruction era to talk about the use of the Posse Comitatus Act and how Congress kept for itself the power to say where the Posse Comitatus exceptions lie, that the president couldn't just come up with an exception. It has to be an explicit act of Congress. So then the court says that in this case, plaintiffs allege that defendants have violated the Posse Comitatus Act and in doing so infringed California's police power, which gives, the court says, which gives California standing to bring this lawsuit. The police power is the quintessential power that the Constitution reserves to the states. The Supreme Court in 2000 held that observing that the reservation of police power to the states is one of the few principles that has been consistent since the Constitution was adopted. So that infringement allows the state of California to say that this is a violation of the Posse Comitatus Act, and we have injury in fact cognizable in law, fact and law, that our state power, our police power was infringed upon. Then the court talks about the exception that Donald Trump brings up as the exception to the Posse Comitatus Act. Recall that the president federalized the National Guard under 10 U.S.C. 12406(3), which provides that the president can do so whenever the president is unable with the regular forces to execute the laws of the United States. The defendants argued that 12406(3) is an exception to the Posse Comitatus Act, so the act does not even apply to federalized National Guard. And then, Major Harrington says that in his training, he put it that everyone knew that the Posse Comitatus Act applied. And, however, this court expresses that the Ninth Circuit's view on 12406(3) being a valid invocation of presidential discretion to override Posse Comitatus was not, would render Posse Comitatus obsolete. And if that were the intention of Congress, they would have done so, but that's not what 12406 does. The Ninth Circuit's expansive view of presidential discretion to invoke 12406(3) affects the viability of defendants' argument that the statute operates as an exception to the Posse Comitatus Act. Their argument, when combined with the Ninth Circuit's reading of 12406(3), would create a loophole in the Posse Comitatus Act that would swallow the entire act and the Insurrection Act along with it, as 12406(3) would place no meaningful guardrails on the federalization and use of National Guard troops and would thereby render the Insurrection Act redundant. And so, you notice again that just like with tariffing, using the IEPA, because it is limitless power, gives the federal executives limitless power, 12406(3) also takes away meaningful guardrails put in by the Posse Comitatus Act and put in by other statutes that would limit the power of 12406. And in 12406, the Congress makes no express intention of overriding the Posse Comitatus Act. That was not the intention of 12406(3). The court therefore concludes that 12406(3) is not an exception to Posse Comitatus. If the president wants to avoid the act, PCA's restrictions, he must invoke a valid exception, like the Insurrection Act, along with its requisite showing that state and local law enforcement were unable and unwilling to act, which the defendants were unable to show because they kept the local law enforcement in the dark until 2 hours before they were going to execute their missions, which goes to show that they were not coordinating with local law enforcement. They didn't even go to local law enforcement in order to ask for help or to provide law enforcement functions. Then the court goes into the Posse Comitatus Act test. Under the Posse Comitatus Act, the military may not engage in activities that constitute the exercise of regulatory, prescriptive, or compulsory military power that amount to direct active involvement in the execution of the laws or to pervade the activities of civilian authorities. And we saw, if you read the ruling, you'll see instances where the Guard and the Task Force 51, which was Guard and Marines, were deployed to different parts of California, to different parts of the Central District of California, to barricade, to create barricades, to traffic patrol, traffic control, and pretty much the things that were prohibited in the training session, like seizure, security patrols, traffic control, crowd control, and riot control, and they did those functions, provided that type of law enforcement assistance to the to ICE agents, that violated the Posse Comitatus Act, and because the government misapplied 10 U.S.C. 12406 in saying that it was an exception to the Posse Comitatus Act. It is not an exception to the Posse Comitatus Act, because an exception to the Posse Comitatus Act has to be explicit, and it wasn't in 10 U.S.C. 12406. The court then boils it all down to what the question is. The question is whether the military has executed domestic law or actively assisted with the execution of domestic law, which would violate the PCA, or whether the military's involvement is so indirect as to not violate the act. And based on the fact pattern, it proves closer to them having conducted domestic law enforcement activities in violation of the Posse Comitatus Act. Starting with history, there's little support in the founding era for an inherent constitutional authority for the president to call forth the militia or to use the military generally to execute laws. Founders did not intend that the militia clause to be used to deploy the military to execute domestic law unless absolutely necessary. In the 19th century, Congress did on occasion expressly grant President the authority to use the militia, but such authority came from Congress, not Article 2 of the Constitution. Then the court goes into explaining that when the president works with the authorization of Congress, if his act is held unconstitutional under these circumstances, it usually means a federal government was an undivided whole, as an undivided whole lacks power. When the president operates in the absence of congressional grant, there's this twilight zone of power where Congress and the president shares that power. But when the president takes measures incompatible with express or implied will of Congress, the president's power is at its lowest, and he has to rely on his constitutional powers minus constitutional power of Congress over that matter. So there's this zone, there's this, pretty simply put, when you work with the Congress and explicit assent of Congress, the president's power is at its highest. When there's no law, or when there's an ambiguity of law, that there's Congress and there's president who has authority, then there's a twilight zone gray area. And when there is a contradiction or incompatibility with the will of Congress, like here with the Posse Comitatus Act, then the president has to rely on his core powers enunciated in the Constitution or explicitly given to the president by Congress that would allow the president to execute the law. So that's the scope of presidential power. Congress was clear about what constitutes an exception to the Posse Comitatus Act, an express provision by either the Constitution or by Congress itself. In doing so, Congress occupied the field and precluded the president from exercising all but his express constitutional authority. The president thus cannot declare an exception to the Posse Comitatus Act any more than he can refuse to follow it outright. As Youngstown says, where it gave the scope of presidential power, the Supreme Court held that presidential claim to a power at once so conclusive and preclusive must be scrutinized with caution, for what is at stake is the equilibrium established by our constitutional system. So, essentially saying it is Congress's domain to tell the president when there is an exception to the Posse Comitatus Act, and that the Congress did not do that under 10 U.S.C. 12406(3), which is what Donald Trump is using to say that it applies as an exception to the Posse Comitatus Act, when the law that he's using does not say anything about an exception to the Posse Comitatus Act. Law enforcement activities are not insulated from the Posse Comitatus Act just because they are framed as property protection. There's no question that federal personnel should be able to perform their duties without fearing for their safety. But to use this as a hook to send military troops alongside federal agents wherever they go proves too much and would frustrate the very purpose of the Posse Comitatus Act. Then the court talks about the conduct and says the record is replete with evidence that Task Force 51 executed domestic law in these prohibited ways. They set up traffic barricades, did the Operation Excalibur in MacArthur Park, went to the cannabis farms to create perimeters, and all this points to Task Force 51 engaging in prohibited activities in Los Angeles. Indeed, Task Force 51's troops clearly qualify as troops' conduct clearly qualifies as Posse Comitatus Act violations under tests that courts use to apply the act. Defendants' lack of cooperation with state and local counterpart raises red flags. It also highlights the lack of any showing by defendants that state and local authorities were unable or unwilling to execute the laws before defendants deployed troops to engage in typical law enforcement functions. So there was no an attempt by the federal government to cooperate with the state and local authorities, which even 10 U.S.C. 12406 requires. These actions demonstrate that defendants knew that they were ordering troops to execute domestic law beyond their usual authority. Whether they believed that some constitutional or other exceptions applied doesn't matter. Ignorance of the law is no excuse. Defendants' systemic use of Task Force 51 troops to execute domestic law in and around Los Angeles violated the Posse Comitatus Act. So that's where the court talks about, essentially says, plaintiffs have proven that defendants exceeded the authority delegated to them by Congress and directly violated the Posse Comitatus Act's specific prohibition against domestic military law enforcement. No doubt, defendants have an inherent interest in safety of federal personnel, but they can and must ensure the safety in a lawful manner, such as, for example, by coordinating with state and local law enforcement. Defendants have no legitimate interest in violating the Posse Comitatus Act for protection or any other reason. The government cannot suffer harm from an injunction that merely ends a lawful practice. And the court goes on to saying the 300 National Guard troops remain in Los Angeles have already been improperly trained as to what activities they can and cannot engage in under the Posse Comitatus Act. That raises serious concerns as to whether he intends to order troops to violate the Posse Comitatus Act in other parts of California. And that is what makes injunctive relief appropriate in this case. With that said, the court enjoins the government from executing laws including, but not limited to, engaging in arrests, apprehensions, searches, seizures, security protocols, traffic control, crowd control, riot control, evidence collection, interrogation, or acting as informants, unless and until defendants satisfy the requirements of a valid constitutional statutory exception to the Posse Comitatus Act. With that said, I hope that it helps understand not just what Donald Trump did wrong, but also how the district court reasons that the law that Donald Trump uses to bypass the Posse Comitatus Act isn't actually a vetted and known exception to the Posse Comitatus Act, because that law was never intended to be an exception to the Posse Comitatus Act, because had it been so, Congress would have to say so. And Congress has not said so, and the law, the Posse Comitatus Act, is still law of the land because Congress has not overridden it with any subsequent legislation. So, thank you for listening. Keep it up. Keep interacting. Keep engaging. Keep talking to people about what's happening in the country. Keep raising an alarm for how Donald Trump's actions are violating constitutional provisions and laws that have been in the books for hundreds of years and has not been violated in a manner in which they are being violated now. And of course, this will be appealed, and we will see what the Ninth Circuit has to say about this portion of the claim and this ruling. It seems quite sound to me, and we'll see how it goes. Thank you so much. Please like, share, and subscribe, and I'll talk to you soon.